broken too. People bending, broken rules. Hound dog howling, bullfrog croaking. Everything is broken.
Hello and welcome to another edition of Dad's Divorce. Today we're going to deal with what to expect at an initial consultation. We have been getting a lot of emails from potential clients and clients on what to expect during initial consultation, what documents should I bring, what questions should I ask. So we're going to dedicate this episode to try to help, one, answer the questions that have been posed to us, but two, to try to alleviate some of the anxiety and the stress and the fears of that first initial contact or that initial meeting with your divorce attorney or the attorney that's going to help you out on a modification. So there are certain documents that are real important if you're going to consult with an attorney and go for an initial consultation. And those important documents would be W-2s, at least your most current one, tax documents from what you've filed in the past couple years. Try to bring in at least 3 years if you can. Any list of separate property that would be considered yours or your spouse's that you get, either one if you have brought into the marriage. Copies of any type of appraisals regarding the property that you own, including but not limited to the marital residence. Any current statements on retirement accounts. And also, most importantly, if you've been served with any legal document, whether it be a complaint or an order of protection, a child order of protection, or a petition for dissolution of marriage, you're going to bring those documents in with you as well. So we're going to kind of go through the list and explain the importance of each one, and then explain exactly what to expect at that first initial meeting or consultation with your lawyer. So the first document that I referenced was a W-2. The W-2 will indicate exactly what was the income that you earned for that prior tax year. So if we're in 2009, your employer should have given you by the end of January a W-2, which will indicate the income that you have received from your employer, or if you've had multiple employers, from your employers for the tax year 2008. And that's important because that'll determine, one, the income that the court will look at to determine whether or not child support is awarded, and if so, what that child support will be, and also it'll go and help out determining income and debt ratio. So you've got the W-2, which will indicate what your gross income was for the prior tax year, and in this case, 2008. The next document kind of piggybacks upon that would be your tax documents. So you'd want to bring in, if you had on tax documents that you filed for 2007, 2006, and 2005. And what that helps out is it will help the attorney know what has been the history of their past salary, because you're coming in for the initial consultation and you've made several $100,000, but that's not the norm. The norm is more under $100,000. Then you want to use the prior years to back up the fact that, well, this year for 2008 was more of a spike, and we want to argue that, well, for the prior years, here's what the income is, and the income for 2008 should be taken into consideration. If so, maybe it should be average, but it shouldn't be looked at as that's the income of this particular person or client. And also having the tax documents is actual proof to show not only to your potential lawyer, but to the court and to the other attorney that this is the income that was earned for the prior years. The next document would be any type of retirement accounts. In the state of Missouri, your spouse is entitled to 50% or half of the marital interest of the retirement account. Now, there are certain exceptions to that, which we won't go into today, but just to give you an example, a few of them would be a teacher's retirement account. That is considered separate property regardless of the date of its inception. So we can designate another one of our episodes to what would constitute separate accounts under retirement property, but for today's episode, we're just dealing with what to bring and what to expect at the initial consultation. So you'll want to bring in at least a current statement of your retirement account so we can know what the value is. And also that'll help out determine what was the value at the time of the marriage and what is the value now. Because as I mentioned earlier, your spouse will potentially get up to half of that marital interest in the state of Missouri. The next important document to bring, which I have a list here, would be anything that would evidence any type of misconduct, whether it be having an affair or financial abuse, anything that you would have that could help document and that would help your case to bring to the attention of the court that here's what's caused the breakdown of the marriage or the dissolution, and here's the proof that I have. Because in Missouri, under the statute, one of the things that the courts can do is take a look at conduct that occurred not only during the litigation but also during the marriage and use that to award a disproportionate or an unequitable distribution of the property. And what that would consist of is the retirement accounts, any debt, and potential attorney's fees. So if you can have proof of the fact that there's this misconduct, that just helps your position if this case goes to trial. And also it helps in settling cases too. Be surprised when people come in and their spouse has this affair and they have the proof to back it up. We serve the papers, their attorney contacts us, and we inform them that there's this potential misconduct that's going on. Here's what we know. We don't really want to tip our cards 100%, but we do want to let them know that either we're investigating it or we potentially may have documents that will help either supplement or evidence the fact that there is this misconduct that we are alleging that has happened. And that could potentially help facilitate the settlement process, which helps both parties because either party won't be spending a lot of money on litigation costs, because the more that is contentious, the more your litigation costs are going to increase. The more that can be decided outside of court and between the lawyers or even between the parties, if there's some type of if the parties can be amicable with each other, then that will help keep the litigation costs down as well. And most importantly, what you're going to want to bring to the initial meeting is any pleadings or court documents that you have been served with, which could range anywhere from a motion to modify, a motion for contempt, a complaint, a petition for dissolution of marriage, an order of protection, or order of child protection. That's real important because that gives the attorney that you're meeting with an idea of what's going on and what is either the spouse or the ex-spouse or the parent of the child, because it could be a petition for paternity as well, alleging in that particular court document. Because you're going to meet with this particular attorney and decide what course of action needs to be taken, what allegations are true, what allegations are false. Once you determine that, you're going to want to prepare what's called a responsive pleading, and you're going to get that on file. In each jurisdiction, they're time sensitive, meaning that once you're served with a pleading ranging anywhere from some of the documents that I just mentioned, you must answer within a certain amount of time. And if you don't, then you could potentially be in default. And if you're in default, then the court can grant the remedies or the prayer for relief, or basically what that particular person is asking for in that pleading. And then your only recourse would be to file the motion to set aside the default judgment. And that's spending more time, more money, and it's not a guarantee that that's going to actually be granted by the court. So you're not positioning yourself well if you don't bring in those documents, especially the time-sensitive ones, because even if you are served with documents and you're running up against time, that attorney can petition the court for an extension or contact the other attorney if that person's spouse or ex-spouse or parent is represented. Then we can get a consent and be able to prepare the proper pleadings. Because you want to get not only just an answer, but you want to get a cross pleading on file too, which could either be a cross petition, a cross motion to modify, or you could be in a position where you were served with either a motion to modify, but at the same time the person who served you with that is not in compliance with a current court order. So then your remedy could be a motion for contempt. So there's several issues that will need to be discussed, and by having that particular court document with you when you go into this initial meeting will not just help your attorney out, but will help you out, and you'll be able to maximize the meeting with you and that potential attorney that's going to be assigned to your case. Because then you'll be able to discuss what the next step is, how are we going to strategize, what can I expect, and certain issues that may or may not arise. Most importantly, what you're going to want to do at the initial consultation is be completely forthright with that attorney that you're meeting with.